Ladies and gentlemen, welcome to all of you. First of all, welcome to you, Professor Holger Fleischer. It's a great pleasure to have you here this evening, and you have some exhausting days to come, but nice that you are here tonight. Welcome also to your colleagues from our Nijmegen Faculty of Law, the Dean of the Law Faculty, and welcome also to the Rector of our university, Professor Han van Krieken, and the Chair of our university, Professor Daniel Witbolders. And of course, welcome to all of you interested in the topic we'll discuss tonight, the responsibility of corporations and the role law plays in enforcing that responsibility. I will first give the floor to Professor Han van Krieken for a short introduction.
Thank you indeed, and also on my behalf, very welcome here in Nijmegen, in this nice room with a lot of people. I'm very glad that there are so many young people here, because that's what we discussed before you came. You are here on the occasion of an honorary doctorate that will be given to you the day after tomorrow. You will receive then the laudatio, of course, and all the praise will be given. I won't do that now, but I would like to stress how glad I am that you are receiving this honorary doctorate, because we give that as a university, of course, to persons of high scientific level, real scholars, but not only that. It's also to persons who look beyond their scientific research, and that's what we will hear tonight. We are going to see that. So that's something that is very dear to Radboud University. The science and the education should be of great levels, but at the same time, we would like to look into society and will work with society. And you are a very good example of that. And furthermore, you're the director of a Max Planck Institute, the Institute für Ausländisches und Internationales Privatrecht. I just have asked why, for me as a doctor, international and foreign is very close to one another, but I know that in law it's different, and maybe we come back to that later. So I understand now that that's not almost the same. But being a director of a Max Planck Institute is for our university extra interesting, because we have the only Max Planck Institute on our campus in the Netherlands, and we have 12 professors that are associated to the Max Planck Society, and we look to that as a very interesting group of institutes that we really like to collaborate with. And I know, and on Thursday you will see how Klaartje Bult will also explain that it's not a coincidence that not only you will receive the honorary doctorate, but also she will give the Diaz lecture, which is a prestigious lecture in our university. So thanks for coming here. Thank also for sharing your ideas in debates for this audience. And I hope we have a wonderful few days here. Thank you.
Thanks a lot.
Thank you, Mr. Rector. My name is Marcel Becker. I am Associate Professor of Ethics at Radboud University. I'm a philosopher, I'm not a lawyer. And to make it even worse, most of tonight's speakers are not lawyers. But for tonight's topics, that need not to be a disadvantage. The topic is obviously interdisciplinary, and also because your work touches on so many different branches of thought. I think the only way to do justice to the greatness of your work is to open in Nijmegen now with an interdisciplinary event. I will have first a conversation with Professor Fleischer, about 20 minutes. Then 3 persons will join the conversation, and with each of them you will have a short discussion. And the final part of the evening, of course, you, audience, have the opportunity to ask questions. So first, Professor Fleischer, may I ask you a few questions? My first question is about the relation between corporations on one hand and society on the other, and the possibilities of law to determine that relation. Recently, you published an article about corporate purpose, and you describe in that article that more and more corporations have to define their corporate purpose. As you describe it, it is their raison d'être for their social legitimacy. And just to quote a few of those corporate purpose statements, Bayer, chemical company, science for a better life. Vodafone, we connect for a better future. And Coca-Cola, to refresh the world and make a difference. And your article is about that kind of statements. On one hand, you suggest that this is a new development. You speak about a fundamental reorientation in law. On the other hand, you mention many historical early examples of corporate social responsibility, right, in which there was already discussion about the place of society, of corporations in society. So this raises the question, what's new? And let me be more specific and refer to another honorary doctor of Radboud University. One of the people you mention in your article also is an honorary doctor. Do you know who I have in mind?
No.
Edward Freeman.
Edward Freeman. Oh,
yes.
Okay. Yeah.
So you are in good,
good
the
company. Stakeholder Edward Freeman.
Exactly.
Yes.
Yeah. So I would like to ask you, what is now the difference between his stakeholder approach 40 years ago, he wrote his book in 1984, and your approach, your suggestion of corporate purpose? What is the difference between the two?
Yeah, thank you. Let me first of all express my gratitude for being here, and it's really a pleasure. Also, this kind of setup here, talking to the colleagues from different disciplines. This is really very nice, and I appreciate it a lot. Corporate purpose. That was actually not an idea of my own, but this was something that was invented at the business schools in England. So I started out explaining that Colin Meyer from the SAIS Business School in Oxford and other people came up with the idea of introducing a corporate purpose into the Articles of Association. And so what they call corporate purpose is not what the lawyer thinks the corporate purpose is. So my first point was to realize that here the disciplines are talking past each other. Each discipline has its own terminology, and what Colin Meyer and others have in mind is one thing. What lawyers have in mind when they talk about corporate purpose is a completely different thing. And I mean, the responsibility of corporations to society is really a perennial topic. I mean, it goes back to the high Middle Ages when the first companies were formed in Renaissance Florence, the Bardi, the Medici, and later on the German trading companies in the southern part of Germany, like the Fuggers. And what they did when they created their company, when they set up their partnership contract, they created an account that they called account of God. So some of the profits were attributed to this account of God, and that later went on to church. So this was the starting moment, so to speak, of CSR in the traditional sense. And then over the centuries, we saw more and more corporate philanthropy, corporate giving, in all jurisdictions across the globe. And in the middle of the 20th century, that was the time when the people at the business school, when management scholars realized that CSR was a topic for them. Then CSR entered into a new generation, so to speak. And then there was a huge fight between different schools of thought. Some 50 years ago, there was a famous article by Milton Friedman published in a New York Times magazine. The business of business is business. No? That was his view of the world. So you have to keep apart government on the one side and business on the other side. They work on different principles. That's what he said. And as a reaction, Edward Freeman came up with his book, The Stakeholder Principles. And these are really the two how can I say, the two antidotes. In today's parlance, a little bit oversimplifying, on the one side, the shareholder value approach, the business of business is business, and on the other side, Edward Freeman, stakeholder approach. Every stakeholder contributes to the corporate enterprise and has to have a voice. So that, how that came. And now we are here today, and the idea of Colin Meyer is a little bit more radical. He said, now the CSR thinking is a siloed thinking. It's just about corporate givings, but we have to change the whole attitude of business, and one of his slogans is doing well by doing good. Yeah? So you have to remodel, to recalibrate the business models, and you have to succeed by doing things that are valuable for society. So that's his point.
Yeah, well, thank you for that answer. So the idea of corporate purpose is more radical because it's about your identity as corporation, about who you are as corporation. And that is more radical and more profound than other more superficial general approaches. But at the same time, I get a bit suspicious because I'm a philosopher and I'm an ethicist. Many people are pretty skeptical about these purpose statements. They speak about, again, empty, meaningless phrases. Crisp and catchy is a phrase that you use in your article. Yeah. So now this skepticism has many dimensions. Allow me to approach this from my own discipline, philosophical ethics. I have the impression that the languages of ethics is now incorporated by lawyers. Once there was this clear separation, law is about things that can be enforced, ethics is about more intrinsic inspirations and sincere motivations. But now, notions from the moral domain are put into the legislative domain. Does that work? Why don't we say render to lawyers what belongs to law and render to ethics what belongs to ethics?
Yeah, that's a fair point. I mean, at the outset, CSR was an entirely voluntary concept. Yeah? People could do it, business could do it, or could leave it. Now, what we observe in the legal world, that this creeping in effect happens, what you just described. We see this transgression from the moral dimension to the corporate world, and we see it also at other occasions. For example, in Germany, our corporate governance code says you have to act like an honorable merchant. Yeah? So, what is that, an honorable merchant?
In German is it ehrungsvoller Kaufmann. In German it sounds more beautiful than in English.
Honorable merchant.
Ehrungsvoller Kaufmann.
And I mean, for a lawyer, and I'm a corporate lawyer by training, and my expertise doesn't go beyond that. For a lawyer, this is really not a workable standard because morals are different. Yeah, morals differ, and so I agree very much to what you suggest, that it should be at the outset a clear distinction between morals on the one side and the legal world on the other side.
But when you write about corporate purpose, then you should change into philosophy. You should be a philosopher and not a lawyer. Is that what you in fact want to say?
No, I'm in this piece. I'm just trying to clear terminology between business school people and law school people, and then I'm suggesting in this article that these vague concepts or mission statements are not valuable as a legal device because you cannot enforce them. No? I give you another example. RWE is a major German energy company, public utility company. So they say, our energy for a sustainable life. Yeah? So if you want to enforce that, that's not feasible. Yeah? I mean, the idea should be, or this idea is that the managers act on behalf of these mission statement and corporate purposes. But at the end, or in the end, that is my point, there will be no accountability because our energy for a sustainable purpose can be all or nothing.
Yeah. This brings me to another honorary doctor of Radboud University, You're not the first German honorary doctor of our university. Do you know who preceded you as German honorary doctor?
I must say I didn't do my homework.
It was Angela Merkel. In 2013, she was awarded that degree.
No, I can't count her honorary doctorates. I think she has 30 or 40 or so.
You are in good company again. And in her speech was in the focus. The speech is still on the internet, so you can see it when you're back home in Germany. Was trust, the notion of trust. Yeah. And she talked about it as a politician, but now I will bring it to this topic. What do you think those corporate purpose notions that company use, does it strengthen the trust that society has in corporation, or does it diminish the trust that society has in corporations?
It depends on the company. I mean, one severe and serious problem of corporate social responsibility is greenwashing. Yeah. And of course, if greenwashing happens quite often, that is dangerous for all of us, because the investors are misled and the honest competitors are set at a competitive disadvantage. So CSR and sustainability will only succeed if the problem of greenwashing is addressed seriously and effectively.
Yeah, okay. The others, people will also talk a bit about the corporate purpose. I would like to go to a court decision in the Netherlands. Yes. that you are familiar with. Thank you for studying that. It's about the Shell Milieudefensie case. The Dutch court ordered Shell to reduce its carbon emissions in a much faster pace than Shell originally intended to do. The activists cheered, but the lawyers raised their eyebrows. And as far as I've understood, the legal discussion at the table is now, can the standards of care, in Dutch, maatschappelijke zorgvuldigheidsnorm, you understand Dutch, I refer, thank you for that. That standards of care that we use in private law, can they be used to enforce corporations to improve their behavior? Mm. Because in everyday life, we have mutual expectations, and when someone does not act according to the expectation, he can be held accountable for the damage. But can that line of thought be translated to the relation of corporations to society? What is your opinion about that?
Yeah, well, this is really a sweeping decision, a bold decision. I think it has also made the headlines in Germany. And actually, there is now a case pending in Germany that tries to use the Milieudefensie setup as a kind of legal blueprint. We have an NGO in Germany, German Environmental Aid, Deutsche Umwelthilfe, who 3 weeks ago filed a lawsuit against the car makers BMW and Mercedes-Benz, trying to force them to phase out the combustion engine cars by 2030 on precisely the same ground as the Milieudefensie case here in the Netherlands. We will see. I mean, from a legal point of view, or to me, there are two critical issues. One issue is the judiciary, are the courts the right body to address the question, or is that a question that has to be reserved for legislature? That is the first question. And the second point is, what is the quality or the persuasiveness of the legal reasoning of that case? Regarding the first questions, of course, there are arguments on both sides of the table. I mean, lawyers tend to be conservative. I think that is probably the same here in the Netherlands as in Germany. And they learn constitutional law in their first year of law school, and they get to know something about separation of powers. That is not only a constitutional concept, but there's something behind it. I mean, questions like climate change and responsibilities of corporations, they are very complex and complicated questions. And in order to respond properly, you have to balance different arguments. Climate change is a very important, very pressing issue, but it's not an issue that takes absolute precedence or absolute priority over other issues, like, affordable energy prices for private households, or job security for employers in certain sectors of the industry, and the competitiveness of the domestic industry, etc., etc. And in a civil proceeding, you have a plaintiff and you have a defendant, two parties. And one can make a good argument to say that courts are really ill-equipped to handle such difficult cases. Yeah. Of course, you can also take the opposite stance, and you can say, no, it's not the courts that are ill-equipped, it's politics that is ill-equipped to tackle such a long-term problem like climate change, because politics is typically myopic. Yeah? It looks not beyond next election day, and therefore, in order to speed up the thing, having the courts here coming up with a bold judgment is the lesser evil. No, that's also a point you could say. But let me add a few words to the legal reasoning. And, I must say, I'm not a scholar of public international law, only an ordinary company lawyer. But the legal reasoning, it seems to me, has some flaws. To begin with, corporations are, according to the traditional view in public international law, not subjects of public international law. And the Shell and other companies are not signatories of the Paris Climate Agreement. And so what the court here does is to take a standard from public international law, a soft law standard, and transforms it into an open standard of tort law. And whether you can do it or not, that is a very debatable question. I mean, you have soft law, and suddenly hard law by some kind of incantatory effect. Yeah? It's like in the fairy tales, you turn dross into gold. Whether this is, I don't say that is legally unfeasible. I don't say that is legally not feasible. No? That is a question that is in flux in public international law, but it is a very bold argument to do that.
Okay, well, thank you for this very nuanced and clear answer to that question. But now, just to challenge you a bit more, you spoke about it's a task of politics, okay, but sometimes politics may fail. And recently, another element of this case was that the judge referred to human rights. And to the audience, also in the so-called Urgenda case, the human rights were in the focus. So it may be generally acknowledged that corporations have to respect human rights, but when we start using human rights in climate cases like these, we can put all kinds of obligations on corporations. Do you agree with that criticism on the use of human rights, or can you understand that human rights are used in cases like these?
I mean, the agenda case, we have to sort out different types of legal actions in climate change litigation. One case, a paradigmatic case of which is the agenda case, is actions against the state. And the other category is actions against the private corporation. That's the milieu defense.
And now
case,
human rights.
And coming back to your question, to the first case, this agenda case using human rights, this has resonated very well with public law professors in Germany. This year, in March of this year, the Federal Constitutional Court in Germany rendered a spectacular judgment in Germany on the German Climate Protection Act. and struck down the German Climate Protection Act as partially unconstitutional with a very interesting argument. We have a provision in our Grundgesetz, the basic law, the Constitution of Germany, saying that the state has to take into consideration future generation and has to preserve the natural foundations of life and animals. And together with these human rights, which you cited, Article 2 and Article 8 of the Human Rights Convention, the German Federal Constitutional Court developed a very interesting argument and said we can deduce from our constitution a right to future freedom, to the next generation. And the court said to the legislator, what you have to do is to balance the reduction burdens in terms of carbon dioxide reduction fairly between the generations, between our generation and the next generation. And this opinion was very much modeled after the Urgenda case and of the Dutch court. And yeah, I mean, in sustainability, looking worldwide, there are really two jurisdictions that are the pioneers. One jurisdiction is France in corporate social responsibility, way ahead of the other European jurisdictions. And in terms of environmental protection, human rights protection, it's the Dutch courts that are really the pioneers in Europe and worldwide.
Yeah. Okay, thank you for that. There are many more things to discuss, but they will come when the other guests will join us. I now welcome first Professor Ingrid Visseren-Hamakers. She is Professor of Environmental Governance and Politics, and she has done a lot of work on governance structure that contributes to a sustainable society. Ingrid.
Yeah, so thanks, Professor Fleischer, and also welcome to Nijmegen. Your discussion reminded me of really current debates in my area of expertise, which is environmental governance. So really thinking at a societal level about how we can steer society from an, in essence, unsustainable society to an, in essence, sustainable society. And in my daily debates, we're really realizing that we're moving the environmental debate from the outskirts of society to the core of society, right? So to all of these ethical issues that we just discussed. And that it's really necessary to integrate environmental issues and concerns and sustainability concerns into the core of how we've designed our societies. In the IPBES Global Assessment that I was co-author of, we called that transformative change, or you can call it transitions or transformations. We have lots of nice synonyms for all of these core fundamental changes in society. But in essence, it's really a reorganization of our society, not only in terms of technologies, also in terms of economy. So what's the purpose of our society? Is it economic growth, or is it welfare for humans and non-humans? And also in terms of values. So that's where we get to this legal versus ethical debate, I think. So values, paradigms, and norms. So what really is the basis of our society, and how can we change the basis and the sheer fabric of our society in order to move towards this, in essence, a sustainable society? So the question then is, if we're talking about, for me, morals or legal arguments, to me, are part of the same thing. Of course, each have a role to play. And the question then is, what is this discussion on corporate purpose? How, and this discussion on, to which extent do corporations have a role to play in this transformative change? How can the law play a role in this? So I'm really eager to hear your views on how your current legal thinking and also the limits of the law maybe stand in the way of the transformative change that's so much needed, not only for climate change, but also addressing biodiversity loss and pollution, and also environmental justice questions, actually.
Right. Yeah. It's interesting for me to hear that you stress very much the term transformative change, because that is a coincidence with how I see the evolution of corporate law over the last 50 years. We started out, and when I say we, I can generalize a little bit. I would say that is also the evolutionary path in European corporate law. So we started out in the 1960s, 1970s with what I call protective corporate law. So the protection was vis-à-vis a very narrow group of stakeholders, like creditor protection, like worker protection, like minority protection. And then came that was the 60s and the 70s, and then the late 80s and the 90s. That is what we call the contractual turn in corporate law. And the focus was there on flexibility, on giving people the instruments to adapt themselves to what they would like to achieve. And I call that adaptive corporate law. And we are now, like a decade or so, we have now entered a completely different stage, and I call that transformative corporate law. And
here we go, using the same terminology.
Yeah, that's a good basis for discussion.
Yeah, really.
That is really interesting, but for lawyers also confusing, because you could also say that is political corporate law. Yeah? You see it on all levels. You have the question of gender quotas on boardrooms. You have supply chain responsibility, and we have our climate change and the law. And it is really now at the center of discussion. It's an emerging field of research, and the law has a role to play there, of course. Yeah? And there are several instruments that the law can consider to use on the national level, on the supranational level. I give you some ideas what is discussed, and I can later on say what my opinion is on that. Yeah? I mean, first of all, the law can incentivize the corporations to do what is more climate friendly. You know? That is what we all discuss under the rubrum nudging legislation, to incentivize, to encourage corporations to do better. One piece of nudging legislation is sustainability reporting. So corporations shall report on an annual basis what their track record is in terms of sustainability. So that is some kind of nudging legislation. Then, of course, the law can step in and come up with mandatory legal rules, or it can open up options, a lot of options. An option could be that you can set up a sustainability advisory committee on the boards, that you can increase and enhance the environmental expertise on board. You can also think about incentivizing and even empowering the shareholders. I mean, we have a very popular instrument, that's a European instrument, you have it in the Netherlands as well. It's called Say on Pay. So the shareholders vote on the executive compensation package. If you transfer that to environmental law, it could be a say on sustainability or a say on climate. So that could be one idea how that can be integrated and how the law can use the changing mind of the retail investors and also the institutional investors. So that may be one solution. There are other ways. I mean, financing.
May I interrupt?
Yeah, sure.
So we're getting to the essence of the debate, and I think all of these options are necessary. I really believe in governance mixes, where not only what governments can do, but also what corporations can do, what civil society can do. So how can we together accelerate this transformation towards a sustainable society? What I find so frustrating about these debates is that we kind of know what the problem is. Of course, we need more climate science and we need more ecological research. But we kind of know what the problem is, right? The environmental problems. We kind of know what instruments are necessary and that we have available, right? To tickle corporations in the right direction, or to force them in the right direction, or to stop them from doing really horrible stuff, or to support them in their transformation towards a sustainable production system. We kind of know these instruments. The problem is, one, we don't implement the instruments, and then the question becomes, and the debate stops basically at the list of instruments. And what my current thinking really is how can we, if we have the knowledge about what the problem is, if we have the knowledge about the policy mix or the governance mix that we have available to us, how can we get those responsible, currently in power, to actually do that? And this is what I call transformative governance. So really thinking through strategically with like-minded folks, whether they're working in industry, whether they're a lawyer or a civil society organization or an academic like me, really thinking through how you can create so much noise, activity, and momentum in society that politicians realize that there are folks out there that would actually support legal action, that there are solutions out there where certain companies actually are experimenting with new ways of producing. Because oftentimes the debate stops at, well, there's no political will or it's too expensive, while the current question really is how we can create the societal momentum to actually do what we already know. How would you reflect on that analysis?
I see your point. I think we have started too late, but recently there has been a lot of improvement, and there are a lot of initiatives also on the level of the European Union. There are some very interesting legislative proposals on the table. For example, with respect to sustainable financing, that's green bonds. That's an important concept. There's now a legislative proposal on the table. Green bonds means that the proceeds, the money goes to sustainability project, and that is now a multi-billion, if not multi-trillion business. It was conceived in 2010 by the World Bank, and 10 years later, it is really not an emerging but an exploding market. So this is one example. A lot is happening, and the Commission has announced that in the fourth quarter, in this quarter, it will come up with new proposals concerning directors' duties, for example, concerning executive compensation and some more stuff. There are a lot of ideas. I think the key problem is that we started too late, and now we have to act quickly. And the transformation, the energy transition takes some time. That is a problem of a pluralistic society, that not everybody agrees on this. But I would support what you say. We need a smart mix. We have, on the one hand, this strategic litigation, what we talked about, the Milieu Defensie case, this raises public awareness, etc., etc. We have other means for retail investors to signal that they really would like to see more sustainability, that is social impact investing. So we can, politics and the legal framework can try to steer the investments of retail investors more to sustainability, and so that sustainability can, at the end, perhaps in some sectors, become a business case. Make that attractive for...
You just said that lawyers are pretty conservative, but now you show another face of the lawyers.
I have one more issue that I want to discuss.
Well, I think that you bring up that issue some later, because I think now it becomes time. Now we see a pretty progressive face of law that we ask another lawyer to join the table.
Good idea.
Okay, you will bring up your question later, Ingrid. Tom Salemink. And he is Associate Professor, Company Law.
Thank you, Marcel. Professor. I would like to discuss the role of Dutch company law in the current debate on social responsibility. And Allegedly, it was the German poet Heinrich Heine who wrote, "If the world ends, I will go to the Netherlands, because there everything happens 50 years later." And I'm not quite sure if that proposition in general is true, but with regard to Dutch company law and the debate on social responsibility, there could be an element of truth in it. And this also became painfully clear when reading your recent comparative paper on corporate purpose. The Netherlands on company law certainly is not a front runner. Nevertheless, I'm optimistic, and I would like to see our judicial backlog as an opportunity to learn from other legal systems, to explore what kind of proposals, legislation exists, what does work, what works and what does not. Therefore, I'm curious to know your view on the various proposals that are currently subject of debate amongst legal scholars in the Netherlands. At this moment, there are 3 concrete proposals that are within the domain of company law. The first one is the director's duty on societal responsibility, the concept of corporate purpose, which was already mentioned, and a new organizational form for the social benefit corporation. And I will leave aside the recent, mainly European developments on sustainability reporting and human rights due diligence. And in your recent paper, you already discussed the second and the third proposal, so let's look at the first one. Dutch company law should introduce a duty for the board and its directors to ensure that the company acts as a responsible corporate citizen in society. Last year, 25 Dutch professors of company law advocated for this duty of societal responsibility to be incorporated in Dutch company law. And this summer, it also became clear that those responsible for the revision of the Dutch Corporate Governance Code also have the intention to incorporate a similar duty into the code. The basic reasoning is simple. In order for societal responsibility to come from within the company, the responsibility of the people who are its agents needs to be activated. Well, companies have already explicitly objected to both proposals. They fear that such an open norm won't work and will only lead to lawsuit. See the recent case of Milieudefensie. And the current Dutch statutory provisions on director's duty are similar to the German system of Unternehmensinteresse.
Okay.
And you already briefly mentioned it. In 2017, the German Corporate Governance Code, as you wrote, in an act of moralizing company law, introduced the honorable merchant concept, the Leitbild des erbaren Kaufmanns. The code not only requires compliance with the law, but also ethically sound and responsible behavior, which in a way could be considered to be the same concept as the proposed duty of societal responsibility in the Netherlands. So in short, what is your view on this duty of societal responsibility for the directors? Does it contribute to a solution of the current global and social challenges, or is the reluctance of the companies with good reason? And what are the experience in Germany with the erbaren Kaufmann since 2017?
Yeah. Okay. Let me ask one question back. Introducing this new provision into the Dutch corporate code, would that really change the black letter law in the Netherlands?
Well, that's a good question, because there is debate on if the current norm of the Unternehmensinteresse also takes into account more abstract interests, such as the environmental and human rights.
Yeah.
So you could say that's already in it, but the 25 Dutch professors of company law, they are of the opinion that there isn't, and so that's why we need a specific duty for directors to ensure that the company acts responsible.
Under German law, there is enough latitude for management boards to take into consideration issues such as climate, the environment, biodiversity, and so on. So the decision rule is really that the management board has to balance all the interests, shareholder interests, interests of the workforce, and interests of the local community, etc., etc. So this already shows the weaknesses of this approach in terms of agency costs, in terms of accountability. And we call that in law and economics the too many masters argument. That is referring to the Sermon on the Mount, the Gospel of Matthew. You can only have one master. Yeah? You must have only one master. Because what we can observe in Germany, but also elsewhere, is when you multiply stakeholders, you really increase the latitude of managers, because managers are in a position under the business judgment rule to play each stakeholder out against the other. And in the end, it's management inaccountability and management latitude. So I think this will lead to little, if anything, and the same arguments are made in the American debate. Lucian Babchuk and others writing on stakeholderism or stakeholder governance, they address the same issues, and I think it won't be wise to codify the Dutch corporate law, as you said. It would lead to nothing, and there's an additional reason, that is, it's the enforcement stupid, yeah? Who has the right to enforce this duty. And as German law now stands, and US law and UK law, and probably also Dutch law, the stakeholders have no standing to pursue these goals in court. And that means that we see no cases. We haven't seen any case in Germany for about 50 years, apart from corporate philanthropy cases. So I wouldn't recommend that. I must say there I have a strong position. That would lead to nothing.
And are there any developments on that Leitbild, the Erbaren Kaufmann, or is it?
I wrote a very critical article 3 or 4 years ago. The Leitbild of the Ehrbare Kaufmann was introduced first in Hamburg, where our institute is located, and people were looking really badly at me. But I mean, the problem is really what we discussed, Marcel, at the beginning. The honorable merchant is for a lawyer not a workable standard. Yeah? It doesn't work. And but I can say that on the European level, there are the same approaches as you tell us here from the Dutch colleagues. So one very prominent proposal, which the European Commission is seriously considering, says you have to put in a clause saying the duty of directors is to create sustainable value within planetary boundaries. Yeah, exactly. Yeah, that's. I'm not a fan of it.
No. Maybe a follow-up question. You already.
Okay, when it doesn't take too long time, otherwise you have to postpone it.
Sorry?
Can it be short?
Yeah, I will make it
short answer.
I will make it short. The accountability, because I wanted to ask in a recent paper, Hans de Wulf, here in the audience as well, professor at the Ghent University, takes the same critical approach about shareholderism that. He writes, and he will correct me if I'm wrong with the questions. He says, directors will have no incentive to take into account other interests than those who have the power to appoint and dismiss the directors. So in the Netherlands, you see for this reason that some legal scholars advocate more fundamental changes in company law. For example, to restrict the influence of shareholders, protection against dismissal, or making directors more autonomous. So that could ensure more focus on social and environmental dilemmas instead of the short-term financial results. And in these contexts, the schools also point out to the German system of Mitbestimmung. What is your view on this, the proposed fundamental changes? Should we elaborate on that, or should we look for other means to ensure and encourage social responsible behavior by companies?
Yeah, Mitbestimmung is very interesting, highly political in Germany. That is co-determination on the level of the supervisory board. In Germany, for the big companies like Volkswagen, they have 20 people on their supervisory board. 10 are elected by shareholders, and the other 10 are voted for by employees. That was introduced in 1976 in Germany. So this is a unique legal pattern. Well, it's also the people who like that say it is very successful, and as a kind of evidence say, look at the frequency of strikes in Germany. So there are very few strikes in Germany as compared to other countries and to other jurisdictions. So that is what the politicians and the people from political science call the Rhenish capitalism. Yeah? The close collaboration between employers and employees, between employer organizations and trade unions. That is definitely an asset in Germany for the German economy. On the other hand, it slows down the process. When you look at Volkswagen, how long the decision processes take, and you need more dynamism in boardrooms, and that is, so to speak, the other side of the coin of this compromise society. That is part of the German tradition, co-determination, and we have this concept of path dependency. So co-determination in Germany was introduced as a basic idea during the years of the Weimar Republic in the 1920s. And I'm not familiar with the Dutch ecosystem in that respect. And let me just say that because that's an interesting concept, perhaps also for the audience. We have a discussion in comparative law about legal transplants. That means, like an organ, yeah, treating a legal rule from one jurisdiction to another. And there is really a very intensive literature on the conditions whether legal transplants work or work not. And if Dutch scholars are considering elaborating on this idea, they should consult the literature on the successes and failures of legal transplants.
Thank you. We talk about transformative processes in society as a whole. We talk about the behavior of people in the boardroom. So now we take a completely different perspective. We go to science. We go to Professor Heleen de Coninck. Professor Fleischer already spoke about workable standards. Well, you are Associate Professor of Environmental Science at this university, and in Eindhoven you are Professor of Social Technical Innovation and Climate Change. The floor is yours.
Thanks, and also welcome to Nijmegen. Very glad that you could be here, and it's a privilege for me as just a simple chemist by background turned into social science to be able to ask some questions to a real lawyer, because I don't meet them very often, I have to say.
But the answers are without responsibility.
Of course,
you know
that's understood. I work on climate change, and indeed, as your examples have shown, law is playing an increasingly important role in solving that issue and getting the systems changed there. But I also, indeed, here at Radboud University, work at the Department of Environmental Science. And we try to quantify, and my colleagues try to quantify environmental impact, right? And try to determine, what is the real environmental impact in terms of greenhouse gases or other biodiversity impact. We also study uncertainties, and those uncertainties are large.
Right.
Actually, a number, you should always look at the context of that number. It's often misused. If you want to tweak your assumptions a little bit, you could be an order of magnitude off in terms of greenhouse gas emissions of hydrogen or something. How does law deal with that?
Yeah.
Do you have examples of how that was used in this presumed certainty of quantification? How does that play out in law?
Yeah. I think we will meet the knowledge of environmental science and law meets in the courtroom when we have the tort cases on environmental pollution. And I give you an example, a very prominent case now pending in the German courts. What we see there, the facts of the case, there is a Peruvian farmer suing a public utility company in Germany. On what grounds? The Peruvian farmer has its village at the foot of the mountains. And on top of the mountains, there's a glacier. And the glacier is melting, and the water is flowing into a mountain lake, threatening to flood at some point in time the village at the foot of the mountain. And now this Peruvian farmer, with the help of NGOs, is suing RWE, the energy company, in German courts. And what he wants is, he wants that RWE contributes to the costs of safety measures that are necessary to prevent the severe flooding. That is an early warning system, building new dams, etc., etc. And his argument is, from 1750 to 2010, there are statistics, from serious scientists saying that the contribution of RWE to the pollution is 0.5%. 0.5% of the whole carbon dioxide or whatever greenhouse effects can be attributed, according to serious scientist studies, to RWE. That's his claim. And now in this fact pattern, you see all the uncertainties, because in our language, in tort law, we have what we call a summation delict. There is not only RWE, there is a multiplicity of emitters. So the first uncertainty as to concurrent causation. And the second uncertainty, what we have in front of us is potentially a long-term delict. It's not only last year's pollution, it's 2.5 centuries of pollution. And the next unique fact pattern is that we have a distance delict. So the plaintiff and the emitter are located far from each other. And now the court has to decide the case. And one decisive question is on uncertainty and on causation. So, statistical evidence under the rules of German civil procedure don't count. So, what you have to prove is beyond a reasonable doubt, a causal link beyond a reasonable doubt. And that is a very high hurdle. And the test, the legal test for causation, which we use, is a but-for test. But-for test, or conditio sine qua non formula, means you assume away the action of RWE, the emissions, and if the result is the same, then there is no causal link in the legal sense. And these are the limited, this is a limited potential how courts can handle this question. And let me tell you one more thing, because that's interesting, how you can overcome these doubts. So there's a spectacular theory developed in the 1960s in American products liability. It's called market share liability. You cannot prove that a certain company sells a certain drug, but you can prove the market share of that. And that is now the theory that the Peruvian farmer uses. It's called pollution share liability. So that would be one way to overcome the causal problem or the causation problem, but it is very hard.
So RWE would pay 0.5% of the safety measure cost.
Right. That's the argument in the case, and we will see the case was dismissed in the first instance, but now it's pending before the higher regional court of Hamm in North Rhine-Westphalia, and the court seems to see some merits in the case and has scheduled an evidentiary hearing. And now they are calling for you, for expert witnesses, to give us the numbers.
I have another question, and it's about the sort of the public versus the private sector. In the Netherlands, we want to be climate neutral, whatever it means in 2050 or so. That means system changes in all kinds of sectors, mobility, energy, that's the same everywhere, but also in industry. And we have a lot of large chemical companies, refineries, a steel plant, fertilizer plants. It's a whole ecosystem, and they need to change fundamentally, right? They all run on fossil fuels, and that needs to change within, less than 30 years, preferably faster, which is extremely fast for these companies. So what they're saying is, okay, we can do it, right? Technically, it's not infeasible, but it's much more expensive. So we asked the public sector for subsidies. A debate with these companies always ends up in these companies asking for public support, which there's arguments for that, right? Because many of these products are internationally traded. Other countries don't impose such strong regulations, so they would not be competitive anymore, etc. At the same time, in the general public, nobody gets it, right? Because then, at the same time, they ask for billions of euros in terms of subsidies, but they also make a huge profit. Next year, they declare their profit, and it turns out to be way more than these subsidies, and people don't understand it anymore. What is corporate? I mean, clearly, these companies will have to give up some kind of profit in order to be more sustainable. That is at least what everybody's thinking is reasonable. But what does the law say about that? How much profit can a company still make if it is receiving a lot of public subsidies in order to solve a problem that these companies are part of causing?
Okay, I mean, that's of course a very tough question. Let me say at the outset, if we want to achieve the transition of a whole economy to net zero, we have to coordinate our forces, and the public and private sector have to cooperate very intensively. Let me give you the example, very important, of course, because of the car industry in Germany, electric cars. So BMW, Volkswagen, Mercedes-Benz, they can say, we develop an electric car. But in order to make the transition successful, we also need a nationwide network of charging stations and so on, the whole infrastructure. And that is beyond the financial resources even of huge car makers like Volkswagen. So it really has to be a cooperation between the public and the private sector. I have some hopes with respect to big corporations in institutional investors. Yeah? Institutional investors are huge asset owners like State Street, Vanguard, or BlackRock, or the big pension funds. And they really have the power to make a difference. Yeah? And if they change their attitude towards the corporations will listen to them because they are voting. Yeah? They have a voting power. BlackRock, for example, has about a 3 to 5% stake at every major German company in the DAX 30. So this is a huge leverage, a huge power that can be used, and we see signs of hope that these institutional investors understand that sustainability is a topic for them, and they are pressing very hard those carbon majors, those large-scale polluters of carbon dioxide. I mean, the blame game doesn't lead to much. Mm-hmm. That is my conviction and persuasion. One has to find ways to cooperate, the private and the public sector. And don't forget, climate change is an international problem. Yeah? You need international cooperation, and that is one point. I mean, that could also be argued against the Milieudefensie case. No? That is called the carbon leakage effect. Now, what happens when Royal Dutch Shell is forced to reduce its emissions? Yeah? Who steps in? Yeah? The Russian oil companies, Rosneft, or the Saudi Arabian oil companies? And if that happens, because the global climate is a common good, as the economists say. If that happens, nothing is gained for the climate, for the global climate. And we need cooperations on the national level. We need cooperations on the international level. That is indispensable.
Yeah, that's absolutely true. And that's partly why we have these international negotiations on biodiversity and also on climate change, of course. And at the same time, that requires trust, right? Like your German predecessor, honorary doctorate requires. At the same time, we have competition law, right? Companies cannot share all information. Institutional investors. I know I'm on an expert committee for the ABP, the largest Dutch pension fund.
Yeah.
Also cannot disclose everything. So how can actors collaborate? And it's deep collaboration, right? Because it's big investments, and their continued existence basically depends on it. So it requires a lot of trust in each other. At the same time, the law prevents sharing of information. There's information asymmetries between the different players. How can we solve this? Because basically we cannot collaborate to the degree that we need to collaborate to solve this collective action problem, even nationally, and let alone internationally.
Yeah, you're right. That is a critical point in antitrust law, R&D cooperation. But there are means and pathways to get an exemption from the European authorities and also from the national authorities. It is true we have a strict ban on cartels, but the second subsection says there can be exemption. Of course, not for hard price cartels, but for R&D cartels, for example.
This is beyond R&D, yeah? This is investments in new installations, and it's not R&D anymore.
They need cost sharing because the financial burdens are too heavy for one of them. And this happens. I mean, if you look at the car industry, sharing of information, sharing of platforms to build new cars, this happens. Of course, there's always a legal risk to that, but I'm not an expert in competition law. I used to teach competition law earlier on, some 20 years ago, but I think that is a manageable risk. That is not the most critical issue, and you can handle that.
When you have such a global perspective, I think the final question now can be asked by Ingrid before we go to the audience. Ingrid?
Yeah, sure.
Yeah, so you make the case for cooperation and coordination, even at the international level, and that assumes collaborative prioritization. Because you can only coordinate together if you prioritize the same issues. And I think if you look at the history of environmental policy over the past, let's say, half a century, we've lost the art of prioritization, I would say, through this. You've used a lot of language that I often use as well. Co-determination, in the Netherlands we call it polderen, pluralism, compromise, consensus type decision-making processes. So through this attempt of being inclusive, we've lost the art of prioritizing one societal important goal over the other. So everything is win-win-win. Everything is people, planet, profit. While hopefully we're looking for ways to prioritize planet and people over profit, or at least to have them inform the way we make profit, and even question whether profit is appropriate in all cases. So how to deal with this need for prioritization and coordination, and this current practice of policy making and perhaps lawmaking, I don't know, of deliberation and consensus. So how can we move forward towards, I have some answers, but I'm really curious to hear your answers to how can we change the culture of policy making to the, I would say, the start of environmental policy in the 1970s, where we were able to prioritize and make laws that prohibited certain environmental impact, activities with certain environmental impacts, et cetera, et cetera. So how do we go? I don't want to go back to the 70s, but how do we take some of us might want to, I see on the first row. But how do we take how do we get back to the essence of environmental policy making, where we say, okay, this is literally, if we talk about corporate law, this is where the buck stops. How do we get there from a corporate law perspective?
I mean, maybe I'm the wrong person to ask that, because this has some, I think this has some psychological overtones. This has implications to political science. I mean, the difficult thing is everybody in this room agrees that moving faster in terms of climate protection is essential. But then we see that the energy prices for the private households is climbing. And so parts of our population say that is not tolerable. The state has to intervene. Yeah? We need affordable energy prices. I have to drive to my work 50 kilometers from the countryside to the city, etc., etc. So it is very hard to convince really a substantial majority of the populations that we have to act. That is something a lawyer cannot answer. A lawyer can say a promise is enforceable or not enforceable. A lawyer can come along with his toolbox. No? I can show you a lot of instruments, what corporate law can do. I mentioned some, there are others. I'm a big fan of evidence-based corporate law. Yeah? So really make an impact assessment, make a proactive impact assessment. What are the instruments that work best in terms of climate protection? There we can make use of comparative law. We can bring in our experiences from other countries, from other continents. What are really the kind of regulation that is working? Is it mandatory legislation? Is it soft law instrument? What really works? But your question is so tough, I have to say I'm out. Yeah.
But it's great that you now, being in the Netherlands, talk about comparative law and comparing different law systems, and then have a better look on what works and what doesn't work. Okay, thank you.